Welcome back, dear students. Today we will learn what is the concept of writ of prohibition as provided in our constitution. Dear students, we have studied the concept of five writs in the previous lectures also. And these five writs, are habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Today we are going to learn in great detail as to what is a writ of prohibition. You see, writ of prohibition is issued to the court or any tribunal to bar them from doing something what they are about to do. And this bar is applied wherever a subordinate court or tribunal hears the matter beyond their jurisdiction or on the matters on which they have no jurisdiction. So if the lower court is going to decide a case in which they do not have jurisdiction, or if they are going to decide the case beyond their jurisdiction, then writ of prohibition can be issued against subordinate courts and tribunals. Dear students, the meaning of prohibition, as is clear from the word prohibition itself, that it means we prohibit. The constitutional courts, high courts, and the apex court are going to prohibit you not to do a function which is beyond your jurisdiction. So the purpose of writ of prohibition is that a writ of prohibition is issued by a court to prohibit the lower courts, tribunals, and other quasi-judicial authorities from doing something beyond their authority. And this writ is issued to direct inactivity. And thus it differs from mandamus, which directs activity. In the writ of prohibition, something is prohibited. And in the writ of mandamus, something is positively or negatively directed to be done. Whereas in prohibition, things are not to be done. This writ of prohibition prohibits the court or any other authority to which it is issued to refrain from doing something which the court or tribunal is about to do or going to do. This writ prevents the court or any other authority from assuming or threatening to assume jurisdiction which it does not possess. So, dear students, in nutshell, this writ of prohibition is issued by a superior court to inferior court for the purposes of preventing inferior courts from usurping a jurisdiction with which it was not legally vested. In other words, to compel inferior courts to keep within limits of their jurisdiction, the writ of prohibition is issued. And dear students, this writ lies only against judicial and quasi-judicial bodies. It does not lie against a public authority which acts purely in an executive or administrative capacity. This writ does not lie against a legislative body also. So, dear students, this writ of prohibition basically means to forbid or to stop, and it is popularly known as stay order. This writ is issued when a lower court or a body tries to transgress the limits or powers vested in it. A writ of prohibition is a writ directing a subordinate court to stop doing something the law prohibits. This writ is often issued by a superior court to the lower court, directing it not to proceed with the case, which does not fall under its jurisdiction. So dear students, we can divide this writ of prohibition into two parts. One is alternative prohibition writ and second is peremptory prohibition writs. An alternative writ or alternative prohibitory writ directs the recipient to immediately act or desist and show cause why the directive should not be made permanent. This alternative prohibition writ may be issued during the pendency of the main writ of prohibition. It may be issued on the very first day when the writ of prohibition is filed and an interim application for stay order is filed. So that interim order is an alternative writ, alternative direction, which directs the respondent to immediately act or resist or desist and then show cause as to why the interim order should not be made permanent. And after the alternative writ, the final order is peremptory writ. Peremptory writ of prohibition directs the respondent to immediately act or desist and return the writ with certification of its compliance within a certain time. So this is the distinction between alternative writ and peremptory writ. That alternative writ is issued in the beginning, maybe on the very first day when the writ is filed in the court, and peremptory writ directs the respondent to immediately act or desist and return the writ with a certificate of its compliance. That is the final peremptory writ. So dear students, whenever an agency of an official body is the target of the writ of prohibition, the writ is directed to the official body over which the court has direct jurisdiction, ordering the official body to cause the agency to desist. Meaning thereby, only that court can issue writ of prohibition which has jurisdiction over the subject matter and territorial jurisdiction also. If cause of action for a writ of prohibition has arisen in the territorial jurisdiction of Delhi, then Allahabad High Court of UP will have no jurisdiction to issue writ of prohibition, because only that court has direct jurisdiction in whose jurisdiction the lower court is situated or the cause of action has arisen. Here is a leading case before you. Rural Litigation and Entitlement, Kendra versus State of UP. This case was decided in 1988 by the Supreme Court. Fortunately, dear students, I was associated in the drafting of this writ petition when I was practicing as an advocate at Dehradun way back in 79 to 84. So luckily I drafted this writ petition, although it was decided later on in 1988 when I joined judicial services. So the Supreme Court prohibited the taking out of limestone from the quarries in the mountains of Dehradun. This extraction of limestone from the mountains was causing imbalances in the environment. Thus, Supreme Court stopped the taking away of limestones from quarries in the mountains under writ of prohibition. This is one of the good example of writ of prohibition. In this case, the interim stay order was also issued, and then final peremptory writ of prohibition was issued against state of UP. At that time, Dehradun was part of state of UP. Now it is in Uttarakhand. So dear students, this is one good example of writ of prohibition. Now let us see what is the distinction between a writ of prohibition and certiorari. You see, whenever a case is pending before a court, it can apply both prohibition and certiorari. Prohibition to prevent the court to proceed further with the case, and certiorari for quashing what has already been decided. Thus, the object of prohibition is prevention rather than cure, while certiorari is used as a cure because the lower court has already decided the case, they have already passed the order, so it can be quashed, it can be rectified by writ of certiorari. So a wrong has been done which can be cured by certiorari. Whereas if the matter is pending before the court, so prevention is better than cure. In those circumstances, writ of prohibition is issued to stop the lower court from proceeding further. So this is the distinction between prohibition and certiorari, that prohibition is applicable during pendency of the suit, and certiorari is applicable when the case has been decided or the order has been passed. So now, dear student, it is crystal clear that a writ of prohibition is issued primarily to prevent an inferior court or tribunal from exceeding its jurisdiction in cases pending before it or acting contrary to the rules of natural justice. This writ is issued by a superior court to inferior court from usurping a jurisdiction with which it was not legally vested. Or in other words, you can say this writ is issued to compel inferior courts to keep within the limits of their jurisdiction. Thus, this writ of prohibition is issued in both the cases. Where there is an excess of jurisdiction, court has to be stopped. And when there is absence of jurisdiction, again lower court has to be stopped. So, this writ of prohibition can be issued in both the cases. Whenever the lower court is going to exceed its jurisdiction, lower court can be stopped. And where the lower court is acting without any jurisdiction, still it can be prohibited by means of writ of prohibition. So dear students, the writ of prohibition can be issued only when the proceedings are pending before a court. Is it clear now? The proceedings are pending in a lower court. If the proceedings have matured into decision, the writ of prohibition will not lie. Because you cannot prohibit a court because they have already decided a case. And when the court before whom the matter is pending has ceased to exist, in that condition also, the writ of prohibition will not lie. Why? Because the court has ceased to exist. Certain circumstances, the courts are created for temporary basis also. Like fast track courts were created temporarily to tackle the problem of pendency of cases before the courts. And now those fast track courts are not working. Their duration, their time limit has already expired. So writ of prohibition cannot lie against fast track courts because the court has ceased to exist. So in such circumstances, the writ of prohibition will not lie because none of the proceedings are pending and there can be no proceedings upon which it can operate But on the other hand, if the court is functioning, writ can be issued at any stage of the proceedings before the inferior court or tribunal. It can be issued only against a judicial and quasi-judicial body and not against a legislative or administrative body. I'm writing here the example where the court has ceased to exist, that is fast track courts. Fast track courts are not working. They have ceased to exist now. So if the court has ceased to exist, or if the court has become functus officio by pronouncement of judgment or by finally passing an order, so in those circumstances, when the court has ceased to exist or has become functus officio, court has finished its work so far as a particular case is concerned, then writ of prohibition will not lie. You will have to go for the writ of certiorari only. Now, dear students, to put the matter in different shape, I'll give you different features of writ of prohibition. And feature number one is command for courts and tribunals. The writ of prohibition is a command of superior court to the lower courts and tribunals. This prohibition commands the courts or tribunals to whom it is issued to refrain from doing something which it is about to do. It prevents the courts and tribunals possessing judicial and quasi-judicial powers from assuming or threatening to assume jurisdiction which it does not possess. The duty of the high courts all over the country and apex court, that is Supreme Court, it is their duty to prevent the courts and tribunals possessing judicial and quasi-judicial powers from assuming or threatening to assume a jurisdiction which it does not possess. According to law, they do not have jurisdiction, and still the lower court is proceeding with the case. For example, suppose family courts have been created all over the country, and a civil judge senior division is going to decide a case of divorce in the presence of family courts. Because now civil judge senior division has no jurisdiction no jurisdiction to decide a case of divorce because the jurisdiction has been given to family courts. I'm mentioning here for your benefit. Civil judge, junior division, or let us say senior division. Civil judge senior division now has no jurisdiction to decide a case of divorce since family courts have been created. So if a civil judge senior division under misconception or under ignorance of law is going to decide a case of divorce, then a writ of prohibition, command from superior courts can be issued against the court of civil judge senior division, who is going to assume a jurisdiction which it did not possess. Civil judge senior division was previously authorized to decide cases of divorce. I also decided so many cases of divorce when I was posted as civil judge senior division, but later on family courts were created under Family Courts Act 1985 and jurisdiction of civil judge senior division was taken away. So feature number 1, dear students, is command of the High Courts or Supreme Court for subordinate courts and tribunals. Feature number 2, prohibition is much common with certiorari. As I told you, that writ of prohibition and certiorari, both writs lie against judicial and quasi-judicial bodies, but not against executive bodies. The object of both the writs is to restrain inferior courts from exceeding their jurisdiction. This is feature number 2. Feature number 3, the stages when these writs can be issued. So whenever an inferior court takes up for hearing a matter over which it has no jurisdiction, writ of prohibition can be filed, and writ court can issue an order forbidding the lower court from continuing with the proceedings. This is feature number 3, that whenever an inferior court takes up a matter for hearing over which it has no jurisdiction, then writ of prohibition can be filed. And writ court can issue, High Courts or the Supreme Court can issue an order prohibiting the lower court from continuing with the proceedings because they do not have jurisdiction. And dear students, if the court has heard and pronounced a decision, if the lower court has heard and pronounced a decision, then the aggrieved party has to file a writ of certiorari for quashing of the impugned order. And so long the court has not decided the case, it is pending before them, then writ of prohibition can be issued. Now feature number 4, where lower court has partly the jurisdiction to decide and partly it exceeds the jurisdiction. Sometimes 2 or more cause of actions are joined together. Maybe that for one cause of action, the lower court has jurisdiction partially to decide it. And for other cause of actions, they do not have jurisdiction and they are going to exceed their jurisdiction. So in such circumstances, the writ of prohibition will lie against doing what is in excess of jurisdiction. The portion which is within the jurisdiction of the court is fine, they can decide it. But the portion of the relief which is beyond the jurisdiction of the lower court, and they are going to decide it, it has to be prohibited by writ of prohibition. Then feature number 5, dear students, writ of prohibition if action is not permitted by law. If something is prohibited by law and still the lower courts are going to do it, writ of prohibition will lie. Here is a case before you, Hari Narayan Roy versus RTA, the case decided by Patna High Court. What happened in this case? That Regional Transport Authority had no power under section 62 of MV Act to entertain an application for temporary permit during the pendency of application for a new permit. The position of law is clear that section 62 says that Regional Transport Authority cannot entertain an application for issue of a temporary permit during the pendency of main application for permit. No interim permit can be issued. But the RTA, Regional Transport Authority, had still issued a temporary permit because the main application for grant of permanent permit was pending before him. So they issued a temporary permit. So it was held by the Patna High Court that grant of temporary permit was beyond the powers of Regional Transport Authority. And a writ of prohibition was issued against Regional Transport Authority, prohibiting him from proceeding with the application for issue of a temporary permit. If you do not have power of issuing temporary permit, you cannot do it, because if action is not permitted by law, You are not authorized to do it. You are not authorized to pass an order for issue of a temporary permit during the pendency of application for permanent permit. This is feature number 5. Feature number 6, plea of alternative remedy is not applicable in the writs of prohibition. Maybe that there is a alternative remedy available to me, but the court who has no jurisdiction is going to decide my case what alternative remedy will do. That is a secondary issue now. Since the court has usurped a jurisdiction which it did not possess by law. So availability of alternative remedy is immaterial so far as issue of writ of prohibition is concerned. We have a very old case, Bengal Immunity Company Limited versus State of Bihar, decided by the Supreme Court way back in 1955. In this case, Supreme Court observed that the existence of alternative remedy may be more relevant in the context of certiorari. But where inferior tribunal has shown to assert a jurisdiction which does not belong to it, so the existence of alternative remedy is irrelevant and writ of prohibition has to be issued. The question of alternative remedy is relevant while issuing a writ of certiorari. The question of alternative remedy may be relevant in the beginning when the suit was filed originally before the court. But once an authority or a court or a tribunal or a quasi-judicial body, they have acquired a jurisdiction which never belonged to them. They assert a wrongful jurisdiction. So in those circumstances, existence of alternative remedy becomes altogether irrelevant so far as issue of writ of prohibition is concerned. So dear students, this is all about regarding the concept of writ of prohibition to be issued by various high courts under Article 226 and under Article 32 by the Supreme Court. So thank you very much, dear students. God bless you.